Hello everybody and welcome to History Bite number 187, dated February 17th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled Thurgood Marshall's Supreme Court Legacy. Thurgood Marshall served as an Associate Justice of the Supreme Court of the United States from August 1967 until October 1991. 24 years, nearly 2 generations. It goes without saying that the world at the time of his retirement was very different than the world at the time of his appointment. When Marshall joined the court in 67, he became the colleague of several judicial legends of the day, including, but not limited to, Chief Justice Earl Warren and Associate Justices Hugo Black, William O. Douglas, John Marshall Harlan II, Potter Stewart, and William J. Brennan Jr., who for the next 2 decades, William J. Brennan Jr. would become Thurgood Marshall's closest and virtually unbreakable ally while on the Supreme Court. All right, the two very, very rarely voted at odds with one another in the 23 years that they served together on the Supreme Court. And were pretty much, you could say, 2 peas in a pod on virtually every issue. You know, I don't think before or since have you had 2 justices that were as much in unison as those 2 were. Thus, it is no surprise that when Justice Brennan retired in 1990 from the court, Marshall, of course, would follow up in 1991 with his own retirement. After all, those 2 were a force to reckon with in their time, and just one wouldn't be enough. All right. So, Justice Marshall's service on the court can be broken down into 3 specific periods. In 24 years, he served under 3 Chief Justices: Earl Warren from 1967 to 69, Warren E. Burger from 1969 to 1986, and William Rehnquist from 1986 until his retirement in 1991. Throughout his tenure on the Supreme Court, 24 years, once again, Marshall remained a steadfast liberal, committed to protecting civil rights, equal protection of the laws, and individual rights. All right. Justice Marshall did not let history, precedent, or text stop him from doing essentially what he felt was right. One of his most famous statements with respect to his judicial philosophy was, you do what you think is right, and you let the law catch up. All right, that's a very powerful statement. You know, he wasn't going to be bound by what he viewed as injustice. All right, he was going to do what was right. Okay, when the law catches up, if it catches up, let that come when it happens. All right. So when Justice Marshall joined the court, in 67, he was a part of the very liberal Warren Court, and thus he was surrounded by many justices who were of the same mindset as he was. Okay, some were even farther to the left than he was. Okay, and thus this was the period where arguably he flourished the most. Okay, in the progressive Warren Court. All right, one of his most famous opinions from that era was Stanley versus Georgia in 69, a very important First Amendment case regarding the possession of certain types of printed material and the viewing of such material in the privacy of your own home without state interference. All right. With Warren's retirement in 69, it then became the Burger Court. All right. Chief Justice Burger took Earl Warren's place that year. And at that point, the court slowly began its rightward evolution. All right. In addition to Chief Justice Burger, President Nixon also appointed Justices Harry Blackmun, Lewis Powell, and William Rehnquist to the court. All of these members initially pushed the court to the right. All right. Been with that in the 1970s, when the court slowly began to back off of some of the Warren Court's liberalism in certain areas such as defendants' rights, criminal defendants' rights, and civil rights. All right. The Burger Court took an interesting turn and actually moved forward with respect to women's rights in, very important cases such as Roe versus Wade, Eisenstadt versus Baird, Reed versus Reed. All right. With a tremendous amount of these women's rights cases being argued by the late, great Ruth Bader Ginsburg. That's right. She had a very decorated history before arriving at the Supreme Court in 1993. And because of her powerful advocacy for women's rights, she was often known as the Thurgood Marshall for women's rights, as he was for the civil rights of African Americans. All right. So in this period, Marshall found himself increasingly in dissent while on the Supreme Court. And some interesting opinions of his while he served on the Burger Court from 69 to 86 were Emporium Catwell Company versus Western Addition Community Organization in 1975, federal labor law case, as well as Santa Clara Pueblo versus Martinez in 1978, a very important Native American law case. All right. In both of these decisions, Marshall saw the bigger picture involved and protected the interests of what he viewed as those who were downtrodden and essentially being stepped on by the powers that be. All right. So a notable dissent also from the Burger Court era with Marshall was his dissent / concurrence in the Bakke case, where, he chastised the majority for striking down the affirmative action program in question in that case. All right. So Marshall's views here at this point are obviously, even in dissent, which is where he shined for the vast majority of his tenure on the Supreme Court, Marshall speaking on behalf of those who have received the less than desirable end of the stick. As I said before, he unwaveringly supported, the rights of criminal defendants, civil rights petitioners, and those seeking individual rights in other circumstances, With respect to capital punishment, he was an unwavering abolitionist. Marshall never, ever in his entire time on the court, supported the administration of capital punishment, viewing it as a violation of the Eighth Amendment's ban on cruel and unusual punishment. All right. Even though I personally do not support capital punishment, I do not agree with Justice Marshall's logic there, as the Constitution certainly approves of the practice, albeit very defective and flawed, via the 5th and 14th Amendments to the Constitution, as long as it's done with due process of law. So as we move into the 1980s, we see the addition of more conservative justices appointed by President Ronald Reagan. We see Justice Sandra Day O'Connor in 1981. We see Justice Antonin Scalia in 1986. We see the elevation of Associate Justice William Rehnquist to the court center chair with Berger's retirement in 1986. And we see Anthony Kennedy's appointment in 1988. All of these members initially pushed the court further to the right, although some moderate victories were occasionally squeezed out in the 1980s. The vast majority of the decade, as well as the 70s, saw Marshall and Brennan, frequently in dissent, Occasionally, they would be joined by what I would like to call the court's evolving liberals, who were originally appointed as conservatives, Justices Harry Blackmun and John Paul Stevens. These four frequently would be in dissent from the more conservative justices during the Rehnquist court years while Marshall served. And, their dissents were, of course, very pronounced. Okay. Key case here, of which Marshall was the only one who didn't dissent, was McCleskey versus Kemp in 1987, a case involving the racial disparities of capital sentencing in the state of Georgia. Bowers versus Hardwick in 1986, a case involving gay rights in the administration of a sodomy law. All right. Ultimately, Bowers v. Hardwick has been overturned, but unfortunately, McCleskey versus Kemp remains standing. Okay. So we see then the entry into the 1990s. All right. With the last appointment, which occurred during Marshall's tenure with David Souter in 1990. All right. Souter would, as we know, become a very left-leaning justice, but during his time in first year, the only year he served with Marshall from the 1990 to 91 term, he certainly was anything but a liberal. All right. So, with Brennan's retirement, all right, which led to Souter's appointment, Justice Marshall, with his health very much failing at this point, decided to retire himself. Okay. He was not able to fully function, as he once did. His mind was not strong as it was, nor was his body, and thus submitted his retirement in June 1991. He would be replaced by, of course, Justice Clarence Thomas, of who also I have great respect for. All right. Several of Marshall's former clerks have gone on to positions of prominence, such as Douglas Ginsburg, a notable judge on the D.C. Circuit and former Supreme Court nominee, as well as Associate Justice Elena Kagan, who served as a clerk to Justice Marshall in the 1980s. Okay, so definitely an honor, I'm quite sure. All right, so during Marshall's 24 years on the court, he wrote hundreds of opinions of the court and even more dissents. All right, given how he was surrounded more by conservatives than fellow liberals for the vast majority of his time on the court. All right. Justice Marshall died in January of 1993 at the age of 84, but his legacy lives on to this day as a crusader for equal justice under law, not just for some, but for everyone. All right. So if you have any questions or controversies, leave them down below. I'll be happy to answer them. Hope you learned something from this, got a thing or two from it about the legacy of a great Baltimorean, Justice Thurgood Marshall. If you have not subscribed to my YouTube channel, please do so right now. If you would, just hit that little red subscribe button and we'll be in business. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.